In view of the conclusion herein above, no deduction could be made for the period of 13 months from the retired dues of the petitioner, as he has been allowed to work and was paid solely for his work during the period of 13 months after his actual date of retirement without raising any objection by the respondent. Accordingly, the decision to recover and consequently orders for recovery of an amount of rupees 7,12,342 for the pay and allowances able by the petitioner for 13 months on account of his overstay in the service and hereby satisfied in cost. However, considering that the actual date of retirement of the petitioner was on 31/01/2016, his pensionary and other entitlements be calculated, taking the retirement date as on 31/01/2016. No recovery, but your
Yes.
it will be counted from the actual date of retirement. With petition dismissed. However, the blacklisting of the petitioner for 5 years from participating in any tender and doing business is interfered with.
I can see WBC 703022.
Dismissed.
Matters pertaining to Itanagar bench judgment 1 criminal appeal A23 of 22.
Conviction and sentence under section 27, 1 and 2 of the Arms Act 1957 is set aside. However, the conviction under section 506 of IPC in their form. Since the appellant has already undergone the sentence of 2 years, the appellant shall be set at liberty by releasing him from the jail for
Item 2 criminal appeal 14 of 2024.
criminal appeal dismissed.
May I please, Your Lordship?
Yes.
Okay, despite being an old matter, Lordship, I'm constrained to mention item number 11 and 12 of the daily list, Lordship.
11, 12.
Lordship, arguing counsel, Mr. H.K. is not feeling well today, Lordship. Lordship, kindly attend this matter for the day, Lordship.
Why? It's
He is not-
2015 method.
Yes,
Is there
Lordship, I
any
understand,
surviving cause?
Lordship,
You are
only for that day, Lordship. I am for the petitioner, Lordship. Only for that day, Lordship. 1 day or 2 days, Lordship. He is not feeling well, Lordship. Kindly accommodate.
what is the matter?
I don't have any.
If you don't have any idea, don't make a mention.
Lordship,
2015 method.
kindly for that day, Lordship. He is not feeling well, Lordship.
Okay, on the ground that Mr. H.K. Das, London arguing counsel is not keeping well, Mr. So-and-so, London counsel for the police, London counsel appearing on his behalf, appearing on behalf of Mr. H.K. Das, London counsel, was for adjournment of the matter for 2 weeks. Considering that the London arguing counsel, Mr. Das is not keeping well, the matter is adjourned as a last chance. Just after 2 years.
Made it. Lordship, I beg to mention item number 22 of supplementary list, Lordship. Lordship, similar matter has been fixed on 3rd April, Lordship, compassionate appointment, Lordship. Matter may be, Lordship, that's why, Lordship, this matter may be adjourned for
22?
22, Lordship.
Hmm.
Lordship, similar matter has been listed on 3rd April, Lordship.
How?
Lordship, compassionate appointment, Lordship. Similarly situated person.
How
Lordship.
similarly situated?
Compassionate appointment, Lordship.
And how it is similar?
Lordship,
The facts would have a different of its own, they will have a different facts.
Lordship, no, Lordship, he applied, Lordship, and DLC recommended, Lordship, and SLC not recommended, Lordship. But
So-
Similar matter also listed in several matter, Lordship. Several matter listed in on 3rd April, Lordship. And it will depend upon the Lordship outcome of that.
Whereby all the recommendation of the district.
Not to
school
say some of the matter, Lordship, several matter, Lordship, some of the matter, Lordship, in categories, Lordship, and some of the matter, Lordship, is this type.
You take it up today,
Lordship, but okay, Lordship, but similar matter is pending, Lordship. Let's see.
on the prayer of Mr.
Yes, Your Honor.
Yes, sir, then we counsel for the petition, release this matter after 3 weeks.
Deeply.
3 weeks.
2 weeks.
May I please? My lord, item number 17, my lord.
Hmm.
My lord, another analogous matter is pending. My lord, can it be posted along with the analogous matter?
This is what?
This is, my lord, dismissal from service.
So,
Now, 2 requisition is pending, my lord.
hmm,
Now, one is, my lord, from the initial dismissal order. Then, my
by
lord,
the same person.
yes, same person.
Hmm,
But he made an appeal. Appeal also, my lord, dismissed.
hmm.
And after dismissal of the appeal, he has filed another appeal.
Which one?
Another writ petition. That is, my lord, WBC number 2850/2022.
So this is become in process. This is what? You have not, you
No,
have.
my lord, there are two impugn order in the
No,
two
no,
writ petition.
I say, this is what?
This
again?
is, this present case is, my lord, after the, my lord, appellate order.
Hmm.
And the earlier is, my lord, before the appellate order. So there are 2 impugn order in the 2 writ petitions. So, my lord, both the writ petition
No,
to be
no,
heard.
how can you do that? It should be after the appellate order only.
Now, present case is, my lord, against the appellate, after the appellate order.
Huh.
Now, earlier case is, my lord, before the appellate order. So both the 2 matters may be
So
heard
that
analogous.
matter is becoming, which one was filed earlier point of time? This one or earlier, that pending one?
Earlier on, my lord, 2850/2022.
That become in process.
No, that cannot be, my lord, because there is an impugn order, my lord. If the,
What is the impugn order there? What is the impugn order there?
my lord, 2019,
Saying what? By whom?
he has been dismissed from service.
Huh. Then you file an appeal.
Appeal.
Appeal has been dismissed.
Appeal has been
That
dismissed.
can be challenged together. Not separately.
So, my lord, since, my lord, analogous matter is pending, my lord, let it be posted along with this matter, my lord.
What analogous? How can you unnecessarily burdening these things?
Now-
See, after the proceedings,
Right.
you have been dismissed.
Yes,
There is a provision of appeal,
Right.
statutory appeal. You file an appeal
appeal,
that has been dismissed.
dismissed.
What about the review?
Now,
Revision.
Any
Any revisional provision?
no revisional provision.
So you have filed against that. This is 17 only. This matter is against the appellate order only.
Appellate order. So,
So that dismissal order become in process.
yes, my lord, I am submitting, my lord, let it be posted along with the WBC number 2850/2022. Any day, my lord.
Heard Mr. M.U. Mandal,
MU.
learned counsel for the petitioner. No, heard. Mr. M.U. Mandal, learned counsel for the petitioner, submits that another writ petition
WPC number 2850 2022.
writ petition being WPC
2850 2022.
2020
22.
22. Challenging the dismissal order. Dismissal from service. Dismissal order. A penalty of dismissal is pending. Therefore, the present matter may be listed along with the above writ petition. Since the present appeal, the present petition pertains to dismissal and pertains to, has been filed after dismissal of the appeal, the statutory appeal filed by the petitioner, the pendency of above writ petition with regard to the challenge of dismissal order may not have any bearing. However, for the satisfaction of Mr. M.U. Mandal, and counsel for the petitioner, list this matter along with the petition. For your satisfaction, otherwise, how can you have the two petitions? Unnecessary burdening.
Obligation.
May it please your lordship, I beg to mention item number 14, lordship. Lordship,
14.
we are filing a affidavit in reply today. Also, my senior MK is recently engaged in this matter, lordship.
Huh?
Lordship, we are filing a affidavit in reply today.
Hmm.
Lordship, also my senior MK is recently engaged into this matter. Lordship, let the matter be taken on any other day, lordship.
What is the matter?
Lordship, the matter is regarding the pensionary benefits.
Okay. Mr. Gitumoni Bhattapur and another. Mr. P. Sharma. R. Gohai. Your name is not there.
Yes,
R. Gohai, learned counsel appearing on behalf of Mr. M.K. Chaudhary, learned senior counsel. Senior counsel. Senior counsel.
yes.
Praise the letter may be adjourned for 3 weeks. So as to enable the petitioner to file affidavit in reply. Praise the Lord, list this matter after 3 weeks.
May I please, my lord?
Yes,
Would you consent of the other side? I beg to mention item number 18 of the daily list, my lord,
18.
for adjournment, my lord.
Why?
My lord, the affidavit in opposition is, my lord, required to be filed, my lord, and
What
the
is the matter?
annexures,
What
my
is
lord,
the
this
matter?
matter pertains to cancellation of nomination of SMDC president, my lord, of Lakhimpur district, my lord.
So
My lord, the annexures are very illegible, my lord. Today we are going to receive it from the Lakhimpur district,
what
my
is
lord.
the matter?
18.
What is the status?
My lord, we are going to
Is he
file the,
continuing? Is he continuing as a president?
No, lordship.
Huh?
Another president was selected, lordship.
Selected. So what is the challenge here?
Our participant without informing us, without so cause.
That's a mere formality. New president has been appointed.
On last occasion, directed to file the.
My lord, the annexures are very illegible, my lord. Today we are going to receive it from
Very legible.
my lord. So we are not going to,
If it's very legible, what's the problem?
we can annex it in our affidavit, my lord. As an
You said it's very legible.
no illegible, my lord.
Illegible.
That's why, my lord. 1 week time may be granted, my lord.
Mr. Yes,
H board, my lord.
H. Borwa, learned counsel for the respondent.
Respondent number
Respondent number
Yes.
3.
3, my lord.
3. Respondent number 3. Learned state counsel.
No, my lord. SSA, my lord. On behalf of B. Gogoi.
Standing counsel SSA submits that although he has received the instruction that the documents are illegible for which they are facing difficulty in filing the affidavit. Seeks some more time to take the steps for filing of affidavit. Praise for some, praise for some, praise the Lord, this. 3 weeks in the meantime. It's a go. My file is affidavit. File the affidavit. Yes.
Lordship, I beg to mention item 16, may the matter pass over for the day and may come up after 2 weeks.
Yes, what is the matter?
I am not aware from the
Hmm?
facts.
Hmm?
I am not aware.
You have the brief.
I am not aware.
Do you have the brief?
Yes, sir, I have.
Go through. We'll take it up after some time. If you don't have, you will take the second file. Go through, at least let us know what is the matter.
The payment of pensionary benefits of the petitioner,
Okay,
non-payment of,
so why you are making an adjournment? You don't want pensionary benefit? You don't want pensionary pension to be paid?
yes, yes, ma'am.
So why you are making a mention? Are you not interested? Anyway, on the prayer of MS C. Burman,
J. Pine,
J. Pine, learned counsel. You are J. Pine.
no, my senior is Mr. J. Pine. A. Mahershi,
MS A. Mahershi,
Mahershi.
learned counsel, appearing on behalf of Mr. J. Pine, learned counsel for the petition. Submits a request for a general deliberate for 3 weeks. This is where you list after 3 years.
At least the lordship. Lordship, kindly pass over the matter for the time being, lordship. My senior is in court number 5, legs, lordship.
Lordship, I'm just praying for some. Lordship, may kindly see order is it 27/9/2022. The initial order, Lordship, 27/9/2022.
22,
Yes, Lord.
yes.
27/9. Lordship, no interim protection was granted. And the court directed us to proceed with the recruitment,
Hmm.
just not to publish the result without the leave of the court.
Hmm.
Lordship, one application I have already prepared. Today I am going to file that affidavit, Lordship. Application
For leave.
yes, Lord.
Why you will dispose of the matter today? What's it?
No, Lordship.
Can it be disposed of today?
Yes, your lordship, it can be.
What is this, eligibility?
Yes,
Not
sir.
eligibility, Lordship. Lordship, in fact, what happened, Lordship, these petitioners are seated.
Yes, eligibility. only.
And as per the advertisement, only the state states were allowed to apply. They came
State-
for this
state-
honorable court,
State?
State care.
state tab,
Assam
Assam state,
Okay.
Assam TP. So ultimately court directed them to appear.
Hmm.
But in the meantime, most of the posts were filled up, Lordship.
Hmm.
Court said in the remaining post, you advertise the remaining post, let them apply and consider their application on the basis of their merit.
Hmm.
So that is the case.
Hmm.
Now, in the meantime, Lordship, what happened? An advertisement was published at page 365, Lordship.
Hmm.
And accordingly, a list was also given showing the available vacancies.
Hmm.
Petitioners failed to apply, Lordship, because of post of their eligibility, Lordship. For suppose, Lordship, one of the petitioners is a general candidate and the district in which he wants to apply, in that district, general category post is not available. Now, it was the very direction of the division bench, Lordship. You only advertise the remaining vacancies,
Vacancies.
Yes.
961.
961.
Huh?
16.
16.
My lord, kindly have page
So-
number 317, your lordship.
You, according to the petitioners, could not apply because you could.
Yes, some of the
advertise because-
petitioners could not. There are total 87 petitioners.
Hmm.
Out of 87, 47 has already applied and their results are also hanging, Lordship. If
Their
the-
results, they have allowed to participate.
they have been allowed to participate.
So what remains here now?
No, remaining candidates, Lordship, who were not.
Because they are
could
relying
not
on the
apply.
earlier judgment
Yes.
that seated, he can, they are eligible.
No, court said you can apply,
Hmm.
but only against the posts which are remaining after recruitment. in
Only
terms-
application has been allowed.
Kindly have.
Whatever
Lordship may kindly-
decision, earlier decision.
Yes, Lordship may kindly see the earlier decision at page 318. I'm sorry, Lordship. I'm sorry, Lord. This is 365.
365.
Three 356, I'm sorry, Lord, 356.
Hmm.
This is WA 69 of 24. Lordship, this was against the advertisement issued by the SSA authority, Lordship.
Hmm.
If Lordship comes to the last paragraph, Lordship,
After hearing learning consultation party, this activity is also described in the same terms in place, similar described in the judgment. Ah,
and the operating portion of the earlier writ petition, that is WA 24 of 2022,
is
at page 317.
317.
Last paragraph, Lord,
There can
54.
be no doubt about the fact the ultimate beneficiary recruitment procedure would be the employee.
Itu number ni mili. 53 and 54, Lordship.
I know 52 is also necessary, Your Lordship.
No problem.
So those who were state that Lordship, they were given appointment in the first phase, and the remaining vacancies, that is in the second phase, these petitioners were allowed to apply. So this is an advertisement, Lordship, this WA 24 is an advertisement issued by the state government.
Basically, central state, they are eligible unless they say that some, if the candidate is not proficiency in language,
Lordship,
that can be considered, but then eligibility has already been decided.
Lordship, eligibility of the central state, Lordship, was decided in those, petitions. Lordship.
Yes,
One before the learned single judge, then before the division bench.
yes.
In this present petition, we are not we are not concerned with the eligibility of the petition.
That's what I'm saying.
We are concerned with the vacancies, Lordship.
So what is the case here?
Lordship has just now seen page 317. In the first phase, stated will be given recruitment. In the second phase, that is in the remaining post, these seated candidates will apply and consider their eligibility on the basis of merit, lordship. That was the first case. Second case, lordship, that is the advertisement issued by the SSA authority, that is with Appeal 69 of 24. In 69, court say, in view of the above hearing, the learned counsels appearing for the parties, this appeal is also disposed of on the same terms and conditions as stipulated by this court in its judgment and order dated 3/2/2021, passed in writ appeal number 24 of 2021. So first case was relating to post under the state government, and second case relating to contractual post under the SSA authority law. Now, lordship, it comes to the advertisement at page 65.
Pursuant to the division bench,
Yes, this advertisement was issued. Page 365.
365.
Yes, Annexure 9.
Yes.
Lordship, I kindly read the advertisement there. In
Complaint.
compliance of the Honorable Guwahati High Court order dated 19/7/2021, passed in WA number 69 of 2021, order dated 3/2/2021, passed is WA number 24 of 2021, and order dated 12/2/2021, passes IS civil number 258/2021. Online applications are invited through the official website of Assam Sarva Shiksha Abhijan Mission, that is the website there, only from the writ petitioners involved in the concerned writ petitions who fulfill all other eligibility criteria for filling up of the post of assistant teacher contractual of lower primary school and assistant teacher contractual of upper primary school under the Assam Sarva Shiksha Abhijan Mission, which remain unfilled after completion of the recruitment process pursuant to advertisement dated 24/9/2020. So that was the earlier advertisement. After, that is some other issue. Now, lordship, may kindly see the table. Last column, lordship may kindly see the heading. Posts remain vacant to be filled up from amongst the seated qualified candidates, writ petitioners involved in concerned writ petition. Lordship, may then come to page 67, 367. Here, lordship will see three columns, lordship. The first column relates to lower primary. Second one is upper primary social science. And the third one is upper primary maths and science. Now, lordship, if it comes to the first row, that is serial number 1, that is Borpeta. I'm taking the example of lower primary, lordship. Lordship will see unreserved 0, EWS 0, BC 0, STP 0, STH 48.
So some of them are, they
Already
for
filled
some
up.
candidates, there is no post.
Yes. This 0 showing 0, lordship, these posts were either already filled up or in the original advertisement also these posts were not there. Now, some of the petitioners, lordship, for some of the district were unable to apply because the post they were intending to apply against, lordship, was not taken.
Okay.
So out of the total 87 writ petitioners, 47 could apply, remaining 40 could not.
Okay.
So that is the scenario, lordship.
Yes.
On the first date, lordship, when this matter came up for consideration, court declined to pass any interim order or stay the recruitment process. Court only said you proceed with the recruitment, but before publication of the result, you take leave of this honorable court. Now we have completed the result, lordship.
So what is this writ petition is? They are challenging that your notice.
Yes.
Advertisement.
They want
that
that additional post be created
total
so that they can apply.
916 has to be advertised.
No, lordship, we have now in this present advertisement, lordship, we have 1,153 LP, 135 UP social science, and 70 UP maths and science.
Okay.
But the concerned district, Lordship, suppose the first petitioner want to apply in the Barpeta district in lower primary section. Dear Lordship, this unreserved, there is no post for unreserved. So he cannot apply. So that is his case, Lordship. You create post for us also so that I can apply.
No, it said press advertisement taking into account the vacancies reserved by the Honorable Guwahati High Court by the order so and so in readable 6 May. So basically what they are asking is that 916.
No, 916 was under the state government. So those numbers are different. So Lordship will not go by the numbers. In the earlier writ appeal, those were posts under the state government. Now in the present case, Lordship, that is 69 of 24, that those are the posts under SSA authority. Now under government, Lordship, those are regular posts, but under SSA, Lordship, these are contractual posts. So that is the basic difference. And on the date, Lordship, on
What
which
were the posts
this is assistant teacher.
recorded by the division bench?
Yes, posts are assistant teachers, but SSA posts are contractual posts. Government posts were regular posts. So that was the difference.
No. So they are entitled to all the posts. Apply for. They are eligible for eligible to apply for all the posts. Either SS contractual or regular.
No, we are in the present case, we are concerned with only with the contractual posts under SSA Lordship. That is a different case, Lordship. Another case was there in respect of the post.
No, what they are saying is, you see the prayer,
Yes, Lord.
page 31.
Yes, Lord.
They are challenging your notice and for press notifications taking into vacancies reserved by the Honorable Guwahati High Court.
This is the advertisement, Lordship.
Yeah.
Page 365.
That is 19/7/2020.
Court said remaining vacancies. So these are the remaining vacancies.
So that you have to show, that's it. Otherwise, nothing here.
Nothing, Lordship.
Everything is settled. What they want that maybe they are apprehending that they might have that apprehension that they may not be post in all the district.
No.
All the
Lordship, last date for filing application in terms of this advertisement of 2020 is already over.
So what they're basically saying is, as per the vacancies reserved by the High Court, wrongly or rightly, according to them, it has to be notified. That is what they are saying.
Notified, Lordship. Lordship may kindly say 365. This is the advertisement.
It's okay. I've seen it. They are
Yes.
challenging that. How much?
No.
How many posts is there?
Here, Lordship, we have 1153 LP, 135 UP Social Science, and 70 UP Maths and Science.
Total?
Total, Lordship, it will be around 1100, 1200, 1300, almost 1400, Lordship.
In the
In the new advertisement, yes, Lordship.
1200.
1346.
Okay. So why they are saying that the High Court reserved by the High Court, vacancies reserved by the High Court? What does it mean?
No, High Court did not reserve, Lordship.
No, according to them.
That is their understanding, Lordship. High Court only say, in the remaining vacancies, let the seated candidates apply and you consider their cases for recruitment, Lordship, on the basis of merit. That is what only High Court said, Lordship.
That's why there's nothing in the writ petition. Why?
Otherwise, nothing, Lordship. These are the remaining vacancies.
No, unless they can show that the High Court had reserved certain certain vacancies. What they are saying is you re-notify all the posts reserved by the High Court.
Kindly
No.
have a look at page
High Court,
356.
Lordship, in my humble
Maybe, may not be,
understanding, yes.
unless they show that the High Court had reserved, say, for example, 1,000 posts.
Yes,
right.
Lord. Yes, Lord.
If you have published, notify only 500 posts, they may have a right. But for that, they have to show that the High Court has reserved certain posts. These are the posts reserved as per the direction of the High Court. These are the total posts. But the authority has not published or notified these posts. That first they have to show.
They are
Otherwise,
trying.
if they don't show, nothing remains. If
Yes.
there is this-
Lordship,
how can this petition
Lordship,
be-
if I explain it in a more simplified way, Lordship. Earlier, Lordship, we issued notification around 4,000 posts, Lordship. Out of those 4,000, these 1,350 remain, 1,347 remain.
Because by that advertisement, you made them ineligible.
Yes, in the earlier advertisement, it was specifically mentioned that CTET will not be eligible.
eligible.
Court
So
said
the court has decided that they are allowed.
yes,
They
but
are
in
eligible,
the
they can-
meantime, Lordship, out of the 4,500 posts, except this 1,347, all other posts were filled up.
Filled up.
So in the second phase, Lordship, we have to consider their application against this 1,347
As per
numbers
the
of posts.
direction.
But some of the petitioners could not apply because
There is no post
there is no
in
post.
their respective district or
respectively.
in their
That's
respective categories.
that is my humble.
Category.
Yes.
So what's there?
Lordship, kindly grant me some time, Lordship. My senior will appraise it.
We'll see, or we'll,
Lordship will take up this matter, Lordship. In the meantime, Lordship, as others page are also hanging, Lordship. Lordship will take my
no,
application.
you have completed the selection
It's
process.
already-
Only a declaration of the result.
Only leave of the court is required
To declare
so
the
that we
result.
can declare the result.
So out of 87.
47
out of
participated.
how many petitioners?
Here, Lordship, 87.
87,
47 has applied.
87, 47 applied. So you don't know whether
They are
they will be elected, they are qualified, or they will be appointed or selected or not.
that is a different.
Until that time it is there. We'll take it up, we'll dispose of them. I think, I don't know, subject to what this learned senior counsel will say.
Lordship.
But then the nature of unless they show that the court has reserved particular or certain vacancies to be notified for the petitioners,
Other than the vacancies advertised in the earlier
Uh-huh.
advertisement.
then nothing remains.
So, Lordship, at this moment, Lordship, I'm praying, let the application be filed. I am receiving it within half an hour, Lordship.
You file it. You file
Lordship.
it. Don't-
Lordship
don't
will take up
But
this-
we'll take it after some time or when?
After vacation, Lordship.
Huh?
After vacation, Lordship.
After some time, your Lordship.
It will come along with the IA, Lordship.
That the application will file up, that will be taken after some time.
Hmm?
That the application will file.
Application, he's filing today only. He's filing the application today only. See, whether, I think, writ petition is not maintainable. Unless you show us that, the High Court, court has reserved a clear-cut vacancy of the post. Right? What you are praying is challenging the press, second, the advertisement, saying that to have to notify a fresh,
Showing the vacancies.
all the vacancies reserved by care. Where the High Court has reserved the vacancies?
What has happened, Your Honor? The first time when the petitioners came before this court, challenging the notification wherein they were not allowed to participate,
It's gone.
that ultimately the division bench held,
It's gone.
no, what the division bench held, that the advertisement were in two parts. Let the first part be completed and the second part be completed as per the vacancies. And there were vacancies there. Subsequently, when they published an advertisement, then they showed that it is 0000. That is the malpractice which they have done. Because earlier advertisement, there were vacancies. No doubt, in general, SC, ST, there were all vacancies there. Subsequently, by the order of this court, when advertisement was asked to be published, then they made it 000. Because they say that meanwhile, we have completed the advertisement. The whole recruitment process has been completed. But the division bench order said that don't complete it, complete in two parts, 1 and B. In B, we are supposed to enter into it, but we could not enter because of the vacancies being shown. That is how the other judgment which came, Honorable Justice Sanjay Mehdi, ordered that the whole process is bad because there was an order where the petitioners ought to have been considered. They have not been considered. That's why you formulate the whole list and make it publish afresh. Then now they are doing it and the whole process is going to be completed. Similarly, this is a contextual set of petitioners. They are before this court. So we are asking the same judgment. That is our case. Because this is not a litigation for the first time. We have been fighting it till the division bench. And their division bench held that yes, they are eligible. And there were vacancies at that time. The respected Advocate General also gave a statement, no, there are vacancies, need not worry. And that is how the order was passed.
So vacancies were there, they have notified the
Yes,
certain
but not-
around 1,200 vacancies.
But showing the petitioners who were before this court, but they were also there. They were ought to have been
Was
considered.
it, wasn't identified? Was it identified?
Not identified.
Posts are there, posted, that's all.
But Lordship, what has happened? We applied it offline also. Our applications are already submitted. They could not make it zero.
See, out of 87, 47 has applied. All right. When it was not specified or identified, the post, say for example, Kamrup district, you are from Kamrup, you want to apply. In the decision of the division bench or the court, if it is not identified for Kamrup, this was the post which has to be re-advertised or filled up afresh. Unless it can, if it is not shown, what is the question of?
No, at the first instance only, we have applied offline. Then they came to know that against which district we applied. So it is on their record. Subsequently, they cannot make a different publication. That is our case. On the very first day, when he came before the petition writ court, saying that please allow us, then this court allowed us to file the applications offline. At that moment, they came to know that there were how many posts. Suppose the person applies for Kamrup, they already came to know because the application forms were submitted offline. They ought to have kept this post vacant because the matter was sub judice. So the second advertisement that was bad. That is,
No, ultimately they have been disposed of.
let them
Writ
file the
appeal.
application. Yes, appeal was disposed of.
In the writ appeal only, and in the writ appeal only, this direction was given.
Yes. In the writ court, there was a direction
There's
that
no, specifically, there no identification of the post was made. Only the certain post vacancies to be filled up.
they
That's
were
all.
filing an application.
Anyway, on the prayer of Mr. P. Nayak, London Standing Council, SSA,
Yes, Lord.
and Mr. So B. Kaushik,
I'm for respondent one.
respond number 1. List this matter after 2 weeks. In the meantime, as spread for Mr. Nayak, London Standing Council may file. Well, as well, when they file introductory application.
Application.
Also 23rd. Deeply aware. Public.
Well, yes.
Lordship, additional senior government, Mr. J.K. Goswami is in court number 5. So kindly matter may be passed over.
What's the matter?
Madam, matter like number overstayed service.
Huh?
Overstayed service.
Why you have overstayed?
Madam, due to madam wrong, madam.
Whose fault?
This is madam, definitely madam not respondent side, madam, because madam my in the service room, madam, my madam date of birth was wrongly recorded, madam, and that was madam corrected after my retirement, after 3 years of my retirement. I was retired madam in the year 2017. My actual letter of retirement should be madam 2014. But my service book, the responsibility is corrected in the year 2019, madam. Even in 2023, I was regularly paid my provisional pension, madam. Now, madam, they have cleared, madam. Now, the pension has been cleared, madam. Madam, recovery is, madam, rupees 22 lakhs, madam. They deemed to recover, madam. That is the case. This is not my fault, madam, because, madam, I have submitted my original certificate, madam, in the service book, madam, they recorded my date of birth in the year, madam, 17 to 1957, instead of, madam, 1954.
Your original record is
1954.
1 3
Madam.
1950
54.
54. They have recorded
Recorded was 17 to 1957.
17 2
72. 3 years.
19.
57.
Where it is? Where it is?
Madam, page 27. Madam. 25. Madam.
What is their stand?
No, madam. But page 25. Madam. Can level, madam. That was corrected in the year 2019. Madam.
You retire on?
Retired on, madam, 27 to 2017. My actual letter of retirement should be, madam, 34 2014. But I was retired on 28 to 17, madam, due to wrong manner.
Huh?
Madam, my actual letter of retirement should be, my lord, 34 2014. But I was retired on 28 to 2017, madam. because of the wrong one putting the my date of birth. Page 25, can you have a look at it? Last question, madam. Date of birth corrected on 27/4/1954. Madam, that is white order dated 22/7/2019.
You retire on 17,
17
after 2 years.
after today.
Where's the interim order?
Page 31.
Huh?
Page number 29. 29 and 31. And page 30, madam, the amount is recorded as 20,91,958.
Huh? Where it is?
Madam, last question, madam. Page 30, madam, the last part, madam. Bottom, madam.
Is to be recovered from 20 lakhs, 91,000.
20,91,958. Due to my stay order, madam, that has not been recovered till later.
Who is the concerned department? Director General of Police,
Home Department.
Home Department. You have been paid all pensioner benefits?
Madam,
All,
now,
you
now,
have
now
received-
clear out the question.
What is their strength?
Madam, they have filed an affidavit, madam.
Lordship, paragraphs 4, Lordship, in my affidavit, page 33.
Affidavit of
Affidavit of the respondent, Lordship, it is respondent 5, Lordship.
yes, there are 4.
Yes, paragraph 4.
Concerning which the date of birth in the state voter
Was reported on.
That's all.
No, Lordship, no. This, Lordship,
Writ petition allowed,
para 7, Lordship.
but your pensionary benefits should be counted from the actual date of retirement,
Actual-
2014. Whatever you have been paid, you refund it. Pensionary benefit you have received by calculating from
The last date of actual date of
2017.
Madam,
It should be calculated
2014.
14. Whatever is
My objection should be recorded, Lordship. Paragraph 5, paragraphs 4, 5, and 7, Lordship.
simply you are saying that you were supposed to, he being a police officer, supposed to place the matter.
No, but he was not so and remained silent, Lordship. After knowing the fact,
What was your job?
no, is a
What is your job?
sub-inspector level officer, Lordship.
What is
He was
your-
silent.
What is your job?
Wrongly, it's
I'm helpless. You file an appeal. Reason being, today I have also disposed of one judgment, similar line.
Lordship, kindly observe my objection, Lordship.
Yes.
Yes, Lordship.
I'll record.
Lordship.
Para 5
Kindly
and
record.
6. 4 and 5.
4, 5, and 7, Lordship.
4,
Seven.
5 and 7. Para 4, 5 and 7. You look at it.
Now, I have appeared for respondent number two.
Heard, Mr.
Ekhoniko.
Huh?
Ekhoniko.
A conical learned council for deputation. And you are one,
Lordship, no, all the respondents except two.
Mr. J.K. Goswami, learned additional senior government advocate for respondent number 1325.
Yes, Lordship.
1325. Huh?
3 to 11, madam.
11, the final.
10. One, Lordship, 4, 5, 6, 7, 8, 9, and 10.
One,
1, 4,
not three.
not 3, Lordship, 3 finance, Lordship.
1, 4,
5,
5,
6,
6,
7, and
8,
8, 9,
9.
10.
and 10.
Yes, Lordship.
Treasury,
Treasury, Lordship, finance, Lordship. Standing council finance.
and Mr. B. Chakraborty for respondent number 2. Non-appeals for respondent number 3 and
3 and
3 and
11.
11. Next para. By next para, filing this writ petition. Petitioner challenges the correction of his date of birth from 17/02/1957 to 27/04/1954. After his retirement in the year 2017. And the consequential what is this order? Page 30.
Page 20, madam. And page 30, madam, the amount is recorded, madam, is 20 lakhs 9 not 10.
And the consequential action of seeking a recovery of rupees 20 lakhs 91,958 for the period from
From 34, 2000.
2014 to 28 to 2017 of the
Yes, yes.
pay and allowances of the petitioner on account of overseas in the service. List of- The petitioner was initially appointed as dispatch rider.
Correct.
Writer or rider? It's a rider. Dispatch rider. In the Assam Police Radio Organization. On 16/11/1979. He was promoted to the post of assistant sub-inspector within Bricket, in the year 1991. Then sub-inspector to sub-inspector within Bricket operator in 2016. You were promoted after your actual date of retirement.
Yes.
My lord.
Now, salary has to be recalculated
Yes.
on the basis of 2014, when
But
he
no-
got to have retired. Now his pension has to be recalculated. now.
Pension that
Yes.
will direct.
And that
Well,
excess
directly.
amount will be adjusted.
Yes, yes,
Excess drawn,
yes.
pension law.
You have to refund
Yes.
those excess, not those overstay.
Not that
No,
20
no,
lakhs,
sir.
not that 20.
14 to 17, that pension and also will be counted. Whatever he has received, that has to be refunded. All right.
But-
See, problem is we understand, but the Supreme Court says, and the coordinate bench of this court also, based on the Supreme Court, says that
Traffic must.
there is a negligence on the part of the officials concerned. Because when you are promoting him, right? You need to be little vigilant as an the officer in the department. That's the reason. We understand that there's a reason why unless there is a fraud, manipulation, we cannot blame the police. Next paragraph. According to it is the contention of the petitioner that when he joined the service as dispatch rider, he submitted his HSLC pass certificate before the concerned authority as a proof of his death of birth. The date of birth in fact, as per the certificate, is 27/04/1954. This one. When did you retire?
Retired, my lord. 28/2/2017.
No. The respondent authorities recorded the date of birth of the petitioner as 17/02/1957 in his service book. Yes, sir. Comma, thereby, the petitioner had to retire on 28/07/2017.
28/2/17.
Yes, sir. Mr. So-and-so learned counsel for the petitioner. Some extent. Due to wrong entry of the date of birth of the petition by the rescuing authorities in the service book, the petitioner had actually worked in the services, sub-inspector.
Sub-inspector.
28/02/2017.
Sub-inspector or patron?
Sub-inspector within bracket. It is only in the year 2019 the responsible authorities detected the inadvertent mistake of wrong recording of the date of birth of the petitioner. That too, after the petitioner wrote the serve after 2017. And after his retirement, after 2 years of his retirement. Mr. So-and-so, non-counsel for the petitioner. Non-counsel, not for the non-counsel, submits the since the petitioner has submitted his HLSC certificate before the concerned authority at the time of his initial joining in the service. Which is recorded as 27/04/1954. The recording of his date of birth as 17/02/1957 is due to the fault of the responding authorities. There is no fraud or manipulation on the part of the petition in recording of his date of birth in his service report. Therefore, he submits the action of responding authority in seeking the recovery of rupees 20 lakhs 21,958 from the area and future relief from the DRCH and future relief of the petition cannot be made as the petitioner has already served the department for 3 years. For 3 years.
Even I was
Yeah.
promoted well after my retirement.
whether there be any fault in the part of the petition. And as such, they will interfere with it. Mr. On the other hand, Mr. Let me question Lalu. Addition senior government. We just suppose page 32, page 4, 5, and 7. Mr. B. Chakraborty, Lalu Council. Standing Council. Lalu Standing Council. Yeah, respond number 3, 2. Submission. If this code is, if the court, if the honorable court is of the view that the recovery for overstay cannot be made. At least the ancillary benefits and the consider the financial benefits with regard to pension benefits of the petitioner may be directed to be calculated from the by taking the date as
27/4.
27/4/2014. I have considered the solution of the constitution. Very, very good. I'll continue.
Deep
Continue.
They submitted number that case is fully covered by Rafiq Mashi case. Is
Your pharmacist is a grade 3, grade 4.
grade 3, madam. And in there in their affidavit, they admits that his date of birth was wrongly written in the service book. A lot of people can,
Where it is?
service, their affidavit, a lot of people can. Open it. Affidavit in the police. Para 3, madam, of page,
Page 67,
page 67. Para 3(1), that is reported by the Angel Lordship of,
Affidavit filed by respondent number 2,
yes,
yes, Lordship.
para 3.
3(1).
Is
That
reported to General Health Service should be.
the matter of the lapses made on our payment of pay and allowances to the petitioner retired pharmacist was not done intentionally. The service book of the incumbent was opened when he was in service in Karbi Anglong district. In the said service book, the date of birth of the petitioner has been recorded as 63/17/63. Therefore, as per the service book, his date of return is on 37/22. That on 26/12/22, the petitioner furnished his admit card because he was asked to furnish freshly, and he applied before the authority and he got it. And HSLC certificate through a letter addressed to the Nagaur and informed that his actual date of birth as per his admit card and HSLC certificate is so and so. But his date of birth was wrongly recorded as 1763 on his date of birth while he was serving at Manja. Accordingly, as per date of birth, 1560 recorded in the admit card and HSLC certificate, his date of retirement was 31/5/20. So admittedly, my lord, his date of birth was recorded wrongly in the service book. And there is no misrepresentation on the part of the petitioner. Here, at the time of when he joined his service, my lord, he has provided his admit card and HSLC certificate along with others. So therefore, my lord, if there is no misrepresentation, he cannot be faulted. only page 33, your lordship will can see. He was working as a pharmacist, and page 33. Page 33. He was informed, my lord, as the date of birth is on page 33. He was informed, my lord, as the date of birth is 1560 as per school certificate of Board of Secondary Education. So your date of retirement from service is 31/5/2020. This is dated 19/1/23. So 19/1/23, he was informed, and accordingly, my lord, he was released from service at page 35 on 1/2/23. So now what they are trying to do is, they are trying to recover the amount drawn by him towards salary from that 1/6/2022, 1/2/31/08/2022. Earlier we came before this court. This court directed them to consider the matter in because that time, my lord, we came before the court, my lord, apprehending, my lord, there will be, my lord, deduction of this excess amount, the deduction of his salaries. Then this court directed, my lord, by page 38 to consider the petitioner's representation and in the light of traffic marshal and other cases. But they have not done anything. They have, now they are relying on the 92 office number. Earlier judgment is at page
They have
36.
not considered
They did not consider.
what they are saying now.
Now they are saying, my lord, in view of 92 memorandum, that they are in their affidavit, they have shown page 72. They have not considered anything, even their own representation memorandum. Their own memorandum is there at page 64. First year lordship will kindly see page 64. This is the government memorandum for office memorandum for deciding the cases of this nature in the light of Rafiq Mashi case. This is dated 27 January 22. Page 64.
$64.
Pursuant to the decision of the cabinet meeting held on so and so, para so and so is amended follows. However, when the waiver of recovery in the above mentioned situation is considered, Pension and Public Grievance Department is empowered with financial ceiling of ₹1 lakh in each individual cases where recovery is to be waived. And beyond ₹1 lakh, the excess approval of Finance Department is to be obtained. But pursuant to the cabinet decision dated 28/21, it has been authorized to the Director of Pension for waiving of excess drawal up to 3 lakhs in respect of provincialized schools teachers and PRI exclusively, with the following conditionalities as summarized by Honorable Apex Court in Rafiq Mashi case. So and was decided by the Honorable Court on so and so, wherein the recoveries by the employees would be impermissible or law. Recovery from the employees, so and so, this is.
So after the Rafiq Masjid, they have also
Yes,
issued that
endorsed.
notification.
So now they are saying, after the order passed by this Honorable Court to decide the matters in the light of Rafiq Masjid case, they are saying 92 of his memorandum is applicable. Well, something laughable, my lord.
Yes.
Page 72. So therefore, my lord, this impugn order seeking to recover 23 lakhs, 31,514. And is liable to be set aside, and his pension is liable to be counted from the date of the actual date of retirement.
Actual date of retirement. Not from,
Not from the date of retirement, but
Not
from the
from
actual
the-
date. My lord, I have
From
already
the
given,
date where you have been allowed to retire,
yes,
but it should be as per the certificate.
yes. And my lord, this person, he was
I've
providing,
already passed on.
yes, he was provided with provisional pension that has been
Petitioner
also
knows
stopped.
it very well that his date of birth is wrongly entered, Lordship. The annexure one of my affidavit shows that, Lordship.
Unfortunately, I have delivered judgment today.
Yes.
Can't help it out. You take all the judgment to appeal. Ask Mr. Details will be there. BD Das, one senior counsel assisted by.
Jail.
Jail.
J. Lot, Jamie Lot.
JB Lota, learned counsel for regulation. And MS
D. Bora,
D.
Health
Bora,
Department. Standing
Standing
Council,
Counsel
Health
for
Department.
Health Department. Government of West
Lordship, I am for
Bengal.
reference six, principal accountant.
Then so and so for West Bengal.
Arke Taluk.
Challenge maybe in this position. Is to the action of the responsible authorities in seeking to recover your. Where it is, the amount, where you have.
Amount is a page, my lord, they are saying that your lordship will get it.
Other day, Lordship has directed me to obtain the record, to produce the record, Lordship.
What is there? Any manipulation?
No, Lordship,
Nothing.
it was already corrected.
Page 61.
Rupees 23,31,514. From the petitioner and from the account of 10 allowances paid to him. For overage in the service. From 31/05/2020 to 30/06/2022. What is there in the record?
In the record, Lordship,
We wanted to see whether there is any manipulation. Service book,
yes, Lordship, service book.
any
Admitted already, my lord, in there.
any manipulation or anything. But you have not said in your affidavit. Is there any manipulation?
No, Lordship.
Nothing.
When he was joined in Karbi Anglong, Lordship, it was wrongly recorded. And it was corrected now.
Corrected in 2023.
Yes,
And he is retired on 2022.
yes, Lordship.
22.
He was sent to, yes. No, he was.
You retired on
released
20
on. Yes,
He was retired on 22.
31.
This is correction is by the officer only,
Yes.
by you only.
It's a Nagaon Joint Director of it.
Joby, whatever, this is by you only, correction is by you only.
Yes, Lordship.
We wanted to see whether there is any manipulation or overwriting, whatever,
No,
whoever has made it. But this correction is by your officer only.
by your,
After you detect that his actual date
Yes.
of birth is
yes.
allowed, writ petition allowed.
Allowed
But the pensionary calculation
they have
for
not
pensionary
given.
benefits shall be
All
from the date
pensionary
of
benefits,
actual date
even
of,
gratuity, GPF, regular pension, they have not paid.
no,
even-
everything shall be, that should be the date of your actual retirement will be calculated.
Yes.
Calculation is from the date of actual retirement,
Lordship.
all right?
Department is to forward the pension paper to the accountant.
To the accountant. and
And the recovery attempt should be, that should be.
Within a specific period.
You are not getting anything
Okay, all provisional pension, they have stopped last month.
last month.
Last month, they are not getting provisional pension. This month.
Facts which are different. Yeah. So you should finish it in the afternoon, right? In the second one, it's only page 37. Let's do the first one. Complete the first one, then come the second one. You have to finish today. You are watching it over. Ramadan is over. You can stay till 9 o'clock in the evening, in the night. Huh? 9, 10 o'clock in the phone.
Obligation.
Huh? Ah.
They will, within a stipulated time, they will pay me. All the,
Every,
even then also we'll have to come and file contempt petition.
that direction has not been complied as of now.
Which direction?
First direction. First direction by this court.
No, that is.
That has not been
that
complied.
is not- This is what is, I'm saying, laughable, because my lord, 92 memorandum, they are, despite the order of the court, my
You
lord.
have filed a contempt.
No, I did not file contempt. There is no point because the petitioner is suffering from some brain problem. Obligation.
May please announce it. So,
Yes,
the case relates to dressing allowance of the nursing assistant, my lord.
yes.
Just now, Majumdar was there, my lord. He can make, my lord, and he gave some Supreme Court order, my lord. If that is covered, then matter may be taken, 1 week time may be given to both for it, my lord. So on Tuesday, next Tuesday, matter may be
It
fixed, my
is
lord.
a covered case.
No, I don't know, my lord. I have to go through it, my lord. He gave me this Supreme Court case, some
Let us
judgment.
see.
That is some contempt case.
Huh?
That is contempt case. According to him, main case was relates to.
Where is Majumdar?
So see, he is in code number 1. According to a contempt case relates to the main case. Main case is regarding that allowance of dressing, dress allowance of.
Is it relevant?
My lord,
Same
yes,
matter.
yes, my lord, but I have to go to the fact of the main case, my lord. That's why, my lord. That is contempt case, sir. That's why. my lord.
It's a contempt case.
Yes,
but
my
then
lord.
The order that we had this directed 4 weeks time to the alleged contempt to comply with the orders of the High Court.
Yes, my lord. That is why, my lord, I'm taking some time to go through it. So may fix on
They
Tuesday, my
are
lord.
claiming for
Dress allowance.
dress allowance. And what is your stand?
Our say they are not entitled for the dress allowance.
Because they are not,
They are not
having the requisite
requisition, yes, my lord,
as per
qualification.
the Ministry of
Oh,
Defense.
office memorandum, they are not possessed.
You
the
find
dress.
out,
Yes, madam, find out.
we'll take it up next week.
Next Tuesday, madam.
Heard MS so and so, let me
Yes,
consult
sir.
for the petitioner. On the prayer of Mr. MS G. Gyan, learned
Again,
A. Gyan, learned CGC.
yes, madam.
List this matter on 17, huh?
8 months. When, madam?
8,
8.
0804/2025. So as to enable her to obtain, to show her, so as to enable her to confirm as to whether so as to enable her to confirm as to whether the related, the order passed by the Honorable Supreme Court in the contempt petition number 43307 of 2023 is related, is a similar issue with the present case, which pertains to claim of what?
Dress allowance.
Dress allowance for
Dress allowance.
nursing
Nursing assistant.
nursing assistant
At the rate of
in
18.
the Assam Rifle.
Yes, Assam Rifles. sir.
In the Assam.
Name is Lordship.
Hmm.
The case is that the petitioner was senior, got the repetition, but when the promotion to the post of UDA, there is a impugn order in stay. So she cannot be promoted, page 75. After that, the private respondent who was junior has got promotion, he withdrew this case. Now he is pending for the decide whether they are entitled for promotion or not. As for the fact that in 86, the petitioner,
You have already retired,
one is retired, 21.
huh?
One petitioner, case number, serial number 21, that's retired already. A pensionary benefit if succeed, she will get that because her name was selected for promotion to UDA. But since there is a stay interim order, that cannot be happen. After that, she approached again, and in the meantime, she retired. So now, if this petitioner succeeded, Purnima Chaudhary, and she may get the pensionary benefit.
Why?
My lord, she is selected as number 1 candidate for promotion of the UDA, senior assistant. But because of this case by private respondent, who is the petitioner in the earlier case, she cannot got a promotion. After that,
Both the cases are similar.
yes, similar.
Similar.
Only
How many posts?
post is 2 posts. Was
How many vacancy?
vacancies the 2 at that time. Now there is available. But since petitioners there, they cannot be promoted, my lord, until and unless this petition is disposed of.
Why?
This issue is disposed of.
Why?
Because the government says, the respondent says, official respondent says that we are regularized against the personal post. So from the personal post, the promotion is not allowed. Because our regularization is 2005 against the personal post. Prior to that, we are master of workers. Then we regularize in grade 4. And after serving, we are entitled to promotion since we are graduate or we are.
Which post is the personal post?
Why not?
Which post is personal?
The initial regularization.
Grade 2, grade
Grade 4.
Thereafter, you were promoted.
We are regularized, but we are.
Regularized in which post?
Grade 4 post.
Then
But we are serving the ministerial works because at that time they are
Serving is something different. You are
Yes.
regular in grade 4.
Yes.
Then promotion to
to grade 3.
3.
From grade 4, grade 3, some post there is a selection process. We are selected.
Then now you are seeking promotion to
We are working there grade 3 post since 2007 and 2020 some senior assistant means Barababu, UD assistant post was remained vacant. Our name was sponsored with serial number 1 and 7, but 1 and 3, but serial number 7 approached this honorable court, filed a expertise order. That is why our promotion was not given.
so
And so after that, he got his promotion, and now we are here. They filed a fresh petition from 20. This is pending. This issue.
what about the writ petition?
Petition is withdrawn.
Hmm.
He got after expertise interim orders. She somehow got the promotion. He has withdrawn this. But
Somehow without considering you.
I have not. We are not considered. We have our case is
Have
not.
you challenged that?
We have challenged that.
Have you challenged the
Yes,
promotion
that
of
is
the
why. That is why fresh petitions.
challenge the promotion of the
That private respondent.
he's who is for he or she?
Department company is not here, madam.
Huh?
Department. Only issue your lordship has to here adjudicate is that where we are entitled, we are holding.
Deepak Kalita.
Yes,
You are
Deepak
you are for respondent number 4.
I'm for accountant there, madam.
Okay.
It's not right.
Hmm.
For advertisement as well as madam, permanent council.
And irrigation department, departmental advocates also not present today.
There is no respondent number 5.
Madam, I 21.
But he is only here because the one of the petitioner, 21 retired, 121 petitioner retired. That is why AG is here. Malat, if there is any order regarding his pension or like that, that is why he is.
No, that cannot be. We cannot direct for retrospective promotion.
But issue may be decided, my lord. Promotion given.
No. When the question of your personnel, you have come over. You could not have been promoted to the LDA when your post were personnel. So far as this grade 4 is concerned, once you have crossed that,
That is
barrier,
their plea. Our plea is that, my lord. Our plea is that, my lord. In 86, my lord, there is some political ban or something like that. We are competent persons, but there is some vacant post of typist or LDA. So what happened? We are engaged there. We are working there. We are expecting.
not go.
Then, my lord-
Immediately you are promoted
Yes, yes.
in LDA. You are
Not-
seeking promotion. You are seeking promotion for UDA.
UDA.
You
So-
talk about are they questioning your appointment promotion to the post of LDA?
My LDA promotion is based on selection procedure.
So are there anybody questioning your promotion to the post of
No,
appointment?
no,
in the
that
LDA?
selection procedure is not challenged.
So
Even
why
private,
you are harping on that?
even private respondent also the party to the
So,
selection procedure.
the rule, what is the rule? Where is the rule?
Rule, my lord, Assam Ministerial, District Ministerial Service Rule, 1967, page 54 of this earlier order of this Honorable High Court.
I'm not asking for the order. I'm asking for the copy of the rule.
Yes, rule is with. It is mentioned also page 54, my lord. The rule is with me, I'm supplying you, sir. This is rule. 9B, my lord, there is a provision for promotion. Is ministerial staffs. Rule 9 relation to constitution of the composition selection board.
What
9P.
about what happened to these judgments?
My lord, these facts are I have
Directed to pass considered orders of cancellation of appointment of the respondent number 5 to 13 with immediate effect. In the same time, respondent are directed to initiate the process filling of the business. You can receive the provision and then- Then he'll be given This is regarding what?
My lord, I have given a synopsis of this case, my lord, actually, that was, I have given one synopsis, but the main crisis method is that, my lord, by.
What is the judgment of page 45?
Yes, page 45 judgment, it says that when we are given, we are given the promotion to LDA, some of the master roll workers approach this honorable court, filing the first petition, says that we are senior, so why the juniors are given? And rule says that it should be seniority come merit, but here applying the merit come seniority, we are given the promotion to LDA in 2007. That petition was fine. So the honorable court has held that yes, they are also entitled equality.
Were you a party?
Yes, we are fine.
You are a respondent.
Yes, respond.
So
That writ petition was ended, and with a direction that they should be given a fresh selection process should be held, and they should be given opportunity.
your appointment was challenged
challenge
as
that-
a LDA
LDA.
promotion.
Yes. Then, my lord, what happened? This person there,
And your appointment was set aside.
no, yes, temporary says that till regular selection process taken.
Forget about, be straight,
Yes.
be fair.
Yes,
Your appointment was set aside. Right?
demotion will be direction, the demotion will be yes. Then there is a clause. They allow them to take participate, but these are not qualified. They are metric or under metric. They khalasi or like that. We are highly qualified.
Why not? I'm asking something. You give the straight
Yes.
answer.
Yes, yes. Then writ appellate court has directed that within 1 month, either you regularize them or,
Where is that order?
my lord, that is, my lord, page, annexure, page 68, my lord, from 67 onwards. This is the appellate court's order, my lord.
This is the appeal is filed by you.
Yes, we are the
Huh?
appellant. My lord, last part, my lord, 67, my lord. It is not the case of the appellant that any relaxation was made in this and requirement pointed out the order of single judge in absence of Sunday. This is the direction, my lord, page 68. So, my lord, till date, they have not initiated that, because if we are out, then there will be,
I'm not getting anything.
my lord, there
I'm
is
asking something, you are saying something else.
tax is that
What happened to that? Writ appeal, what is the direction?
either to regularize.
See, number one, your LDA post, somebody challenge you, the appointment you as a LDA.
Yes,
That has been set as a single bench.
yes,
Then you have, the
Approach.
order was taken to appeal.
yes.
What is the order of the appeal? In the appeal,
69 page, my lord, I have just. Accordingly, we dispose of this appeal with a direction that state may either initiate a fresh selection process or take a decision on regularization of in accordance with the rule within 3 months from date of receipt of the copy of this order. Since the appellants have been continuing for more than 6 years, pending decision of the state may be allowed to continue as arrangement, ad hoc arrangement. This was the direction to Honorable Appeal Court, but they cannot initiate a fresh or they have not regularized us. We are continuing last 18 years in LDA. Now, cause of action errors in 20. Some UDA post is there. So we are also selected for promotion. Then this repetition comes. He got, now department says
This
that
repetition comes and it will go.
gone,
It will
Now-
go.
gone. Now,
It has come, it will go.
Gone.
Accordingly, go.
now,
Repetition, go.
now department says that your promotion to LDA is not means improper because you are not entitled for promotion. Department has given us the promotion. Now department says your personal post. Now,
Mr. Borua,
My
I'm
lord.
not getting a head and tail. You said this repetition came and accordingly this will go.
yeah,
Repetition dismissed.
my lord.
That is what you want.
No, my lord. My lord, let me hear it after vacation or one day. I have given
You will hear or this court will hear.
this, your honor, your lord court will give accommodation today. Because government advocate is also not.
So
present.
present today,
Yes,
it appears that your post
LDA.
in you have not been confirmed in the post of
Yes,
LDA. How
my
can
regular-
you seek an the promotion to the higher post?
Yes,
Writ Appellate Court Division Bench has directed the respondent authorities to consider your case fresh for appointment, either by way of regulation, whatever. Till this time, you should be allowed to continue, right?
yes.
That has not been done as on today.
But
Right.
in one case, it is
Why?
done.
Wait, that has not been done in your case.
Two cases, no, one case done, one case not. done.
Forget about that. That
Yes.
has been done.
Yes.
Not has been done. How can you seek a promotion unless you are confirmed and in LDA?
Right.
First, you get yourself confirmed in LDA,
Correct.
then ask for the
I have. Because our Kitar Kadar is LDA.
So
then
what is your prayer here? Promotion to the post of
senior assistant, UD.
writ petition dismissed.
My lord,
Dismissed.
my lord, I cannot.
First you get yourself wrongly or rightly, this court has directed you. And whether they are doing it or there is appropriate remedy you should take.
No, I have taken, my lord. There is an order, my lord. That is why next requisition kindly see, my lord. I cannot today. I have not prepared. There is his
Have
regular.
you been, have you, had
One
your,
petitioner is regularized.
has
my
your
lord.
service been regular?
Regularized yes, in LDA.
Huh.
In one case regularized and another case, my lord, there is no challenge of his LDA, my lord.
What
They-
about you? I am asking about you. What about your service as a LDA?
Item number 20, I am the advocate. Here, no challenge to his LDA. And item number 21, there is regularization in the post of LDA. Well, there, order
Yeah,
says.
Will
Now,
make-
if, my-
will make me crazy.
so that is why, my lord, it should be just immediately after due. I will give a synopsis.
I'm just asking whether your service in the grade of LDA has been regularized or confirmed.
Regularized. 21, item 21 regularized.
Your case.
Yes. Both are my case, my lord. I am the advocate of both the items.
What about 20?
20, my lord, her appointment in LDA is not challenged. She is exempted from that. In order says, my lord, kindly see, there is no challenge to.
Yes, where is the appointment as a LDA? After the division bench.
No, before division bench, we are LDA.
Huh?
Before division bench, we are.
After division bench. After.
After division bench, my lord,
Where is your appointment?
my lord, kindly see 58, my lord, first item. Item,
Eight second.
Rukmini Roy, my lord.
You said.
Rukmini-
First item, then second,
See, page 58, para 19, my lord. Here says that item number 14, 15, 16, 17, solely the ground of appointment order has not been challenged, my lord. So there is no challenge of his appointment order in LDA. The court has not interfered. Page 58, kindly see, my lord. So, my lord, if they I place everything with haphazardly, your lordship may not.
Your status, however, I'm not interviewing the promotion or trial based on 14, 15, 16. Where is your private respondent?
My lord, here, my lord, Rukmini Roy is the private respondent, petitioner here. Page 50, kindly see, my lord. Rukmini Roy. In earlier petition, she was respondent number 14. So her appointment is LDS not challenged, my lord. So it's still regular.
When your appointment note has been set aside, why you have filed an appeal?
My lord, actually group case, my lord. That is the
Lordship,
problem.
Lordship, may I submit, Lordship? I'm very sorry, Lordship. Lordship, may kindly take this matter day after tomorrow, Lordship. I have just missed the case today, Lordship.
No, I am not taking, I cannot take it that way. I'll go mad if I take it up this.
The
This court-
petitioner,
this
Lordship,
court will,
there is-
this
this is-
court will go mad if
No,
such cases are. If I hear the manner you argue the matter,
my lord, that is why, my lord,
make this court mad.
my lord, if I given the liberty, my lord, learned friend also says, my lord, please accommodate today. We come with it fresh, my lord.
Sorry, Lordship.
Heard Mr. So-and-so, learned counsel for the petitioner. And Mr. So-and-so,
And
on the prayer of Mr. So-and-so. H. Barua, J. Barua,
MJ Barua.
MJ Barua, Michael Jackson Barua. List this matter after 4 weeks.
Obliged, Lord. Obliged. I'm sorry, Lord.
Please prepare your case, and it's very difficult.
My lord, I also, there is twist, my lord. Her appointment in LDA not challenge. Now, if lordship says that it is
Michael
interfered-
Jackson twist.
if lordship is.
I'm in item 21 for 800.
Thank you.
Another case, item number 70, somebody mentioned, I appeared for respondent, 70, 17, 17, somebody mentioned without informing me. My name may be recorded only, madam.
Item 17.
17. 17.
Yes, let us finish the orders. Next is hearing, right? Next will be hearing. Let us complete the order. Seven? Ah.
7, madam, this already complied, madam.
Complied.
If board.
What was the direction?
To direction was to bring the proposal that was contained by the communication dated 79 to bring that proposal to a logical end, madam. Now the speaking order has been passed by 29
Where is
3/20.
where is the order? Where is the order?
Well,
The above requirement within the particular bring to a logical and with equivalent control in the family. The above requirement person 2 years.
My lord.
It was supposed to be within 2 months and after 2 years. Huh?
My lord, because the
2023.
yes, because the reports from the other authorities were called for, my lord, to ascertain the enrollment position. Because that's the only criteria, because he is claiming as an additional teacher. And that can be given only when the students, the PTR is to that effect.
Non appears for the
Seven.
petition on hold.
7 months.
It's complied. Of course, there is a delay. 23, rejected. Heard Mr. So and so learned counsel for the petitioner. Next para, Mr. B. Kaushik, learned counsel for Alice Contempt now.
Ballot, respond number 1. Or sole respondent.
Alice Contempt now. By placing the order dated, copy of the order dated 29/03/2023. Commence that. Order of this court. Dated 17/11/2021.
Second to अपने ऐसा ना
1483
second to comply
2021. Has been
speaking order
duly complied.
rejected.
Has been complied. Mr. So and so. Learn counsel for the petitioner. Then they accept it. Accept the argument this court that it 17/11/2021 has been complied with. Huh? You are admitting it's been complied with. Of course, there is a delay of 2 years. Anyway, you have a remedy in view of the above. The contempt petition is things closed and disposed of. Next, a copy of the order. It is 29/03/2023. Document X.
Item 8 also, my lord, it's complied now.
Them also. What is the order?
The direction was to examine the claim of the petitioner and the respondent to pass a speaking order. And the pass a speaking order. That is speaking order has been passed.
Then this. This is of
Director.
19/12/2023. Order of the order plan.
Right? 19/12/24.
Director of the school education. Complied with so and so. Date of order of this court is
Seven.
7/12/2007. It's page number 11, my lord.
7/12/2024. That will be changed, huh? That will be
Get one. 9 to अपना
closing.
Well, actually, as per office note dated 1/8/24, service is complete on respondent number 4. So all respondent services complete. Actually.
All the respond. 7 and 4 and 7.
Yes, Lordship. As
Huh?
per office note dated 1/8/24, it's complete on 4.
What about 7?
7, Lordship, and one earlier office note dated reflects that 7 is already complete.
In view of the order, heard Mr. Swenson learn consulting. In view of the order of Lazima code. That is 0108 to be delivered. Mm, 31/05/2020. Service in respect to respondent number 4 and 7 is complete. Services in respect to respondent 4 and 7 are complete. List of the missing after 3 weeks. 3 weeks.
Obliged.
What if the respondents were directed to seek instructions whether my case has been forwarded to the finance department or not?
Yes, complaint report.
Complaint. In the last order, my lord. This was
3, 1, 2, 3.
yes, ma'am.
Huh?
My lord, 3 documents are there. 4 documents are there. 3 documents are in compliance of the court's order, my lord. And one order is there, my lord, by which, my lord, the proposals were forwarded to the finance department. That was on the last date.
No, these are for three contempt.
Yes.
3 contempt petitions
Contemners, the speaking order
has been passed.
And apart from that, it has been forwarded to the finance department also. That was the
Yes.
query on the last date by the honorable court.
Yes, ma'am.
So that has been complied. with.
Yes, yes,
Yes, Lord.
compliant.
It is stated like the boss. And the third Mr.
As,
Dr. P. Agarwal.
Huh?
Dr. P. Agarwal.
Dr. P. Agarwal.
as doctor.
Or Doctor within bracket. MRS. bracket.
Lordship, it may be directly also, no problem. Dr. P. Agarwal will also.
Dr. P. Agarwal, land
Agarwal.
council for this petition. It will be separate order or same order?
Separate orders, ma'am. 3 orders are there.
Lordship, there were 3 separate judgments which were passed in the 3 writ petitions.
Okay. Then same order but separate, huh? And Mr. So and so.
As doctor.
As Dr. Land council for them. LS contempt. Mr. It is stated that the order of this court. Number 1 is 14/12/2022 passed in WPC number 803
Judgment dated,
2022. Huh?
Yes, ma'am.
judgment dated 16/12/22.
16/12. Page
Passed in WPC number 8038 of 22.
8038.
Yes, Lordship.
That is the order dated 14/12.
Yes, Lordship, it's 14/12.
14/12.
Yes.
2022. Passed in WPC, huh? 8038 of 2020. Has really been complied with. That is. Invariably, the contempt is closed. And disposed of. That is, this is, first one is
790/2023. And in the second case, my lord, contempt number 792, order date was 16/12. Oh,
Second
yes.
one is 791.
791, yes.
The judgment date is 14/12/22. Passed in WPC number 8019.
Yes.
801.
Page 12.
14/12. Same. And then
And in the last one, my lord, 16/12.
16/12/2022, WPC 8105 of 2020. Copy of the separate order. Huh? Copy of the first one is 24. Same, 24 March 2025. Possibly Commissioner Panchayat and Rural Development. Assam, huh? Separate, huh? Same. Okay, so. And it's okay. It's complaint. Yes.
Highly obliged, lord.
If you like. It is on code number 4.
So what is to be done?
I Mazumdar Malak.
Huh?
I Mazumdar.
Ah,
So,
What is to be done?
timely?
Huh?
Timely? Or my lord taken on 8, my lord. That case is also pending, his case 8, no?
This case?
8,
Which
Eight.
case?
my lord. That is a different case, my lord, but his case, my lord.
What is the matter here?
Data matter is removal from service, my lord.
Removal.
Yes, my lord.
Do you have the records?
Record is not required, my lord. Earlier record is not required, my lord. Everything is there, my lord.
Recording is not- Yes. What is the ground?
Aware of this.
On the joint prayer of learning conscience. Mr. MS
As Borpujari.
S. Borpujare. Then council appearing on behalf of Mr. Or Majumdar. And council and MS. A gap. Then it's CGC. For all the respondents.
Yes, ma'am.
Come on, this matter on 080420.
That's fine.
Wait, please, also.
Yes.
But of the petitioners are the charge, well, not he here.
Yes, my lord.
Criminal order has been passed.
No, no, my lord. Actually, what happened? Actually, at the time of this Vishwakarma, when this judgment was, my lord, pronounced, that time they were not charge mechanics, my lord. Subsequently, as per the recruitment rules, only they are promoted to charge mechanic in 2013.
Okay, then we'll hear.
Yes,
Are you ready?
I'm ready. Ma'am.
Make it short. If it's not necessary. Let's make the.
Or should I prepare a short synopsis, my lord, and then, or I can make submissions, like no.
Make your submission
All right, my lord,
wherever it is necessary.
all right. My lord, the petitioners.
You don't have to take all the materials.
Promotion, in fact, my lord, the petitioners were promoted, all these petitioners were promoted in 2014 as charge mechanic.
2014.
14.
Is
As charge mechanic.
charge mechanic.
Charge mechanic.
Earlier,
Earlier, we were vehicle mechanic.
vehicle mechanic.
Yes, from vehicle mechanic to charge mechanic.
Initial appointment is vehicle
Vehicle
mechanic.
mechanic. They are appointed, promoted as charge mechanic. Now, we are promotion.
In 2014.
14. Similar promotees, you know, who were also vehicle mechanic and promoted to charge mechanic, approached this honorable court here
Yes.
to seek benefit of a judgment passed in the case of Vishwakarma. This honorable court held that they are similarly placed, and we are also charge mechanic, they are also charge mechanic, my lord. So they were granted all the benefits. Your Lordship, kindly have a look at the, I'm not going to the judgment right now, my lord. Lordship, kindly look at the list, my lord. The seniority list, my lord, master seniority list. Lordship, that is at page, my lord, 80. This is the page 80 is the seniority list.
80.
80 is the seniority list, which contains, my lord, the names of all the charge mechanics in the same cadre, doing the same work, same cadre.
Including yourself.
Yes, total is 1295 at page 104. Now, my lord, they are, if Lordship kindly come to page 98.
What total is?
Total is 1295. Page 1011, 104. Now, my lord, if Lordship kindly, Lordship got it. Now, Lordship will come to page 98. Page 98. They are giving the benefit up to serial number 977.
977.
Not after that. Now, my lord, the same gradation list, doing the same nature of work,
they are transferable. One can be transferred to the other, my lord. And there is no difference. They are not also disputing that we are doing the same nature work. But the benefit,
Up to 770,
977.
977.
Yes,
Up
but
to
not
that.
beyond that. We are after 977. And
Even after 977.
977. And prior to 1977, they approached this honorable court. Says their plea is that since on the date of judgment we are not there, it cannot be given. Now the principle is, my lord, that it is not relevant when we are appointed. If we do the same work, same nature of job, then the benefit should be the equal pay, equal work should be provided to everybody. This is what the two judgments of this honorable court has held. So, my lord, I will take to your lordship the judgment that passed by this honorable court in the case of, my lord, not Ghanasham Vishwakarma, later Pramod Singh, which followed Ghanasham Vishwakarma. At page, lordship will come to page 60. Page 60 is the judgment. I'll take your lordship to the relevant part of the judgment. Page 60. Lordship, the relevant is page 62, it starts. Page 62. Lordship got it. I'll read only the relevant paragraph. My lord, it says the prayer is to issue writ in the nature of certiorari so and so, or direction like nature towards setting aside the quashing the order so and so, onwards, granting higher pay to the diploma holder charge mechanic than non-diploma holder charge mechanic in the border roads organization without there being any reasonable basis so and so. Now, paragraph 2. If the petitioners are the employees of the border road organization under the Ministry of Shipping and Transport, holding the post of charge mechanic. They were initially appointed as vehicle mechanic, welders, and so same as us. This
Are you a welder also?
welder also.
Turner and electrician.
No. In the petition there is no welder. They all are vehicle charge mechanic. So we initially vehicle mechanic, now charge mechanic. This is the welder. All the feeder cattle.
General reserve in for C and group C. So what is the finally?
Now, my lord, kindly come to the findings.
Being in the cadre of child by virtue of the permission of the state, the same duty and the same as that of the diploma holders charge mechanic.
My lord, come
So
to page.
here the
Petitioners
diploma
are-
holder charge mechanic you are granting higher pay scale.
We want the same higher pay scale as is
You are not
granted.
a diploma holder.
We are not diploma. We have
So
the
this-
other qualifications.
In this petition, the charge mechanic,
We are also not the
non-diploma holder.
not diploma. They were the alternative.
Same scale of pay
Same.
with that of the diploma holders.
Right. That
child
is the prayer.
Yes.
Now page 67. It considered the sixth pay commission recommend paragraph 12. Page 67 got it, lordship.
Nowhere in the official recommendation.
Nowhere in the fourth
It's okay.
recommendation the category employees.
Then
Next, my lord will kindly come to page 70.
Come to about being the position, I mean, when the issue of the which is granting the
Finally, paragraph 10.
allowed their sitting as the crossing and the input of this servicing is to extend the benefit. Yes, then
Page 75 is the writ appellate court's order.
75.
Because that judgment followed Ghanasham Vishwakarma. Here, the appellate court has held.
Things covered the division judgment of this court.
After that, my lord,
This is what?
yes. Now, my lord,
Read direct. 75 is what?
they challenge the last single judge's order in appeal the division bench has held, because single judge has held, it followed the Vishwakarma's case. And say division bench has held, it will follow similarly.
Vishwakarma's case.
Vishwakarma's case. That is also annexed by
So
me.
that means dismissed.
Appeal is disposed of below the same term. Now, my lord, next page. Next page is the order, my lord.
No, Vishwakarma is by whom?
By Vishwakarma, Vishwakarma's case followed the subsequent promotions case.
Huh?
Vishwakarma is also a charge mechanic. He also claims same pay and scale, and which was granted by the Honorable Court. Subsequently, Pramod Singh and others, following Vishwakarma, filed the writ petition. This Honorable Court has this is covered by
Which you
Vishwakarma.
have seen?
Yes,
This one,
yes,
page 72,
Seven.
direction.
yes, yes.
Huh?
Page
72 is the direction.
direction.
So this says followed the Vishwakarma.
Yes, Vishwakarma is also in the same line. Said that should be given the same
Where
benefit.
is the Vishwakarma?
Vishwakarma, I have an next below. Vishwakarma, I lost it 1 to 3 below.
No, this last order which you have seen, the Justice V.K. Sharma,
Yes,
this has followed Vishwakarma.
lost you, exactly. And division points, as I said, my lord, Vishwakarma will, my lord,
Same order.
same order.
Then
Page 76 is the order by them. They say the undersigned is directed to refer so and so, so and so. It has been decided to implement the Honorable Court's order in respect of petitioners only. So this is, the division bench did not say, neither this Honorable Court has said in respect of, this is judgment in rem.
the innocent is directed referred to the regarding government and to say that the matter has been examined, has been decided to implement the Honorable High Court's order in respect of petitioners only.
It can't be, my lord.
This is you are aggrieved.
Yes.
Then
No, my lord. Their case is only this.
this is the only case.
Yes, this is the only case. How can it be, my lord? Same date.
But he has, Mr. Dollar has so many.
He raised, this is the only case.
This is the
And-
that's all.
My lord,
That's why you are aggrieved.
that's right.
So since the judgment is in rem,
In rem.
the equal,
Yes, it says
relief should also be granted.
given to us. That's the case.
That's all.
There can be a difference. That's all.
That's all.
Maybe we are appointed subsequently, maybe subsequent rule or whatever it is.
Yes.
The Supreme Court, I have the judgments, lordship. If lordship, I can give your lordship the judgments.
What judgment?
What is
What judgment?
the equal pay, equal work? What principle? This is also followed in the Vishwakarma's case as well as Pramod
If
Singh's
it is
case.
followed, why we should?
Lordship.
We should.
But then, my lord, I think, my lord, for lordship convenience, I can give your lordship the
How
copy.
much? How many?
3, 4.
No, you give at best one.
Okay, my lord.
At best one. If
Okay.
it is followed, whatever has been followed here, in the earlier, they don't give.
Okay.
If the latest and which has not been considered and followed and considered in the earlier round of litigation, you
Lot.
said that too the latest.
Oh, these are old judgments, but
No,
these
no,
are not.
all judgment,
Any, my lord.
which has not been followed. All right.
Lordship. The principle is well settled.
Yes. So you may place the judgment with regard to the order of the, if the order of the judgment is in rem, it has to be given the
Right,
similar
exactly.
relief should also
On these, I'll just give you.
the
On this.
afforded to the similarly situated.
All right, well, all right. Well.
You just give that.
So that is,
So it has not been taken to Supreme Court.
yes. No.
Up
This
to
is,
division bench only.
lordship.
Your case only division bench. No. This earlier Justice Sharma's case has been taken to division bench.
Division, right? But the
Division
Contempt
bench-
case was taken to the division, it was dismissed.
Okay. So dismiss, therefore, the same will follow.
Same will follow. And 2015 one SSC, they say the court's judgment should be extended to similarly situated, but 2015 one SSC 347.
2015.
One SSC 347.
I'm giving you.
Para
Para 22.1.
22.1.
Lordship.
What's the name of that?
The name of the state of UP versus Arvind Kumar Srivastava and others.
Bill Kumar. Yes.
And my lord, next is I think this would submit. Other judgment, if your lordship after my land plan submits, I can give you lordship.
Very simple.
No, no, my lord. Actually, what happened, my lord, there are four recruitment rules. One was in 1982 recruitment rules and subsequently 1996 recruitment rules, and they were appointed by 1996 recruitment rules. Then, my lord, in 2012 recruitment rules, they have been promoted as a charge mechanic. And prior to that, in 2010, when the Vishwakarma case was pronounced, and all benefits were given. And these petitioners were that particular time, they were not charge mechanic. My lord.
So is the recruitment rule provides the different scale of pay?
Yes. No, yes, my lord. That I'll come to that, my lord. Your lordship may take my affidavit in opposition, my lord.
Page.
Yeah, I just only just a few pages, my lord.
Page.
My lord, in
Affidavit in opposition by only.
Yeah, respondent number 1 to 5.
Page.
Yes, my lord, lordship may come there where I have stated in paragraph 4, my lord. The relief in post.
They have respondent number 1 to 5.
Yes, 1 to 5. Page 2, my lord.
Running page.
Brandon, this is the petitioner not promoted as per the recruitment and the promotion rules 1982.
Running page, sir.
131.
Oh.
131.
Para
4, my lord. Para 4, just a third line. The action that the petitioner were appointed vehicle mechanic on 16 December 1998. But the petitioner was not promoted as per recruitment and promotion rules 1982. And as the same has been suppressed by the reverse recruitment and promotion rules and came into effect 2012, which have been published in GSN number so and so. All petitioners have been promoted to charge mechanic in the year 2014, my lord. And according to the provision by recruitment and promotion rule 2012. Actually, what happened in this case, my lord, the petitioner should have been challenged this recruitment rules 2012. And your lordship may subsequently, this is I have stated regarding the Vishwakarma case, paragraph 8, my lord. Well, paragraph 8, my lord, regarding 6 instant petition, the deponent offer. The petitioner has quoted the subtle law of the Honorable Court in the matter of the writ petition filed by High Court and implemented the preventive faxes case under that already, my lord, they have stated. My lord, that last paragraph, your lordship may come, paragraph 8, last 4 lines. At the time of merging and re-designation of the diploma holders as J's, as well as the pronouncement of the verdict by the Honorable Guwahati High Court.
Where it is?
This is paragraph 8, my lord. Last 4 lines. Last 4 lines, my lord. At the time of merging and re-designation of the diploma holders as J's, as a result pronouncement of the verdict by the Honorable Guwahati High Court in the case of Ghanshyam Vishwakarma, the petitioner were vehicle mechanic and not charge mechanic. As such, they are not eligible to be considered as similar situated cause as the case of the other person, those who were charge mechanic at that time. Then, my lord, I am coming to the paragraph 9, last 5 lines. Last 5 lines, my lord. Further to elaborate the benefit of the higher grade pay have only been extended to the individual who were promoted to the charge mechanics, charge electrician, while the recruitment of the promotion rule 1982 and 96 was in force. But it can be seen that the petitioner and other litigants were promoted in accordance with the recruitment rule of promotion of 2012, where the pay scale has clearly specified PB 15,200, so and so, so and so, the GP 2,400. So it can be construed that they are not similarly placed in all respect as has been charged by Pramod Singh, which my learned friend has quoted my notes. As the others of the day cannot claim themselves a similar place, hence they claim that the petition needs to be rejected out only by. Then my lord, paragraph 10 again, last 4 lines, my lord. At the time of merging and redesignation of the diploma holders as J's, as well as the pronouncement of the verdict by the Honorable Guwahati High Court in the case of Contempt Vishwakarma, the petitioner were vehicle mechanic and not charge mechanic. As such, they are not eligible to consider as a similar situation case in the case of the others parts who were charge mechanic at that time. As per Equipment and Promotion Rule 2012, pay bracket was so and so, so and so. Then, my lord, then in 1992 recruitment rules, it was originally 25% by the direct recruitment and 75% was promotion. And subsequently in 1996, my lord, 33% was direct recruitment and 67% was promotion. But in 2012 recruitment rules, it's 100% by the promotion. Your lordship may
What is this?
page 9, my lord, is a relevant portion. Page 9. Page 9, this is GSR 169. In exercise of the power of the conferred by the provision of the articles of the Constitution and in suppression of the General Reserve Engineering Force GNC
Have
Group
you
D.
annexed this?
No, it is already in the petition. Just for your lordship convenience, just I have like
No, that's on which page this is?
page 9, my lord. Page 9, this is Equipment Rule 2012.
Page 9 of what?
Page 9, I have
Page 9
page
of
9,
what?
I have given your lordship.
This is first page and you are saying page 9.
9, no, this starts from 4. Page, just I have given this.
No, this is it a part of the record?
No,
Is it a part of the record, sir?
No, this is, I have not annexed it, my lord. This I have no, in affidavit of position, I have not annexed it. But this is a recruitment rule 2012, my lord. This is not annexed.
What am I trying to say? By showing this?
Yes, my lord, the promotion there, what I wanted to show, my lord, here, if the lordship may come to paragraph 9, page 9, and relevant, I want to say, by 2012, my lord, it is 100% by the promotion. Here, charge mechanics, my lord, it is by promotion. Earlier in 82, 25% direct recruitment, 1996, it was 33% direct recruitment. Now in the 2012 recruitment results, it is 100% by the promotion only. So they were already promoted in 2004. Then prior to that, all benefits were given. Prior to when this Vishwakarma case was pronounced, my lord, as per that case, all benefits were given. At that time, those who were charge mechanics. But these petitioners, they were appointed only in 2014. Then, my lord, subsequent even what happened, after that, my lord, in 2014, sorry, my lord, this is, again, my lord, on 2016, these charge mechanics also redesignated as equipment mechanic. The charge mechanic, that concept is all gone. That your lordship will find that on page 13, which I have given to just now, lordship. Page 13, 60, serial number 60. Serial number 60, my lord. Here, they have been converted from equipment mechanic, their existing right hand side, my lord. Existing designation of the post of the charge mechanic changed as an equipment mechanic.
So
now they have been working as a now equipment mechanic.
So
my contention is that the Ghanshyam Vishwakarma case will not be applicable in these petitioners. Reason being, they were promoted to charge mechanic in 2014 only. Then, and regarding that, my lord, one, in my affidavit in opposition, I have given the judgment of.
So this Ghanshyam and the Poddar, what is that? Poddar. Pramod.
Yes,
Are they still working?
yes, it's still there.
Still working as a charge mechanic or?
No, equipment mechanics.
Huh?
Equipment mechanics.
They are also equipment mechanics.
Yes, yes, sir.
Petitioner are still equipment mechanics.
Yes.
Nomenclature doesn't change of nomenclature doesn't make a difference. You may have a point that at the time of
They were not charged
promoted
mechanics.
in different rules.
Yes.
What is the rules of 2000 under which this Ghanshyam and Pramod were promoted?
1982.
This has been
Suppressed, my lord, subsequently.
no, that has been superseded
Yes, superseded.
by
2012.
So it's only providing of the pay scale
Yes, yes, my lord.
when the rule was made.
Yes.
You could have incorporated.
But the same
What is
similar,
the judgment of which year?
My lord,
Ghanshyam is which year?
2010.
Then
no, Ghanshyam
when
is,
you have
9 was filed, it was judgment was pronounced in 2010.
Ghanshyam is 2011.
then
10
this
or
is
10,
the rule
No,
is of 2012.
Yes, my lord.
You are relying on the rule of 2000.
Yes,
You could
yes,
incorporate it,
Yes,
which you have not done.
yes.
So just because you have provided in a recruitment rule, certain state, certain pay scale to a particular group of persons in a serving a similar post. The
Similar
appointment
post
may be
means,
different.
similar post means one was diploma holder, one was not.
When the court has intervened, then they are entitled.
Yes, yes, true. So in a similar situation, my lord, just in page 18 of my affidavit in opposition, similar judgment has been passed by the Delhi, by the Delhi High Court.
Delhi
18,
High Court.
18. Affidavit in opposition, page 18.
Para.
No, this is the judgment. This is relevant portion in the last four.
Which is hereby.
This is, my lord, it was pronounced on 23/09/2015.
Rabindra Bhatt.
Now your lordship may peruse the final paragraph 4 of Delhi High Court judgment, my lord. In a similar situated condition, my lord. Paragraph 4.
This court is the consider the petition provides not full fund. Firstly, the petition like the concern
This court is of the considered opinion that the petitioner's grievance in the present case is not well founded. Firstly, the petitioner, unlike the Ghanshyam Vishwakarma case, were not
same post and also ending same status, pay scale so and so could not be discriminated against on the basis of the
no.
That has been distinguished. Ghanshyam's case, Vishwakarma's case,
Yes.
it is premised on the fact that two individuals holding same post and also enjoying the same status, pay scales and other allowances attached to it could be discriminated.
Against the
Alright.
basis of qualification. Subsequently, my lordship held it. At the later date of the consequence of the implementation of a 6th pay commission. In the present case,
Yes.
there is no dispute that the petitioners were never promoted and
Therefore,
therefore never enjoyed the same status privilege at that regular promoted surge mechanism.
Relief can,
Furthermore,
never promoted, they are not the same status
yes.
and privilege.
So furthermore, this court is of the opinion
So
that the
this
relief cannot be
Delhi
granted
High
to the
Court-
reasons.
Delhi High Court has distinguished this case with the Ghanshyam.
Yes,
The
yes.
Ghanshyam is, the Ghanshyam and these people are the same, having the same status, same promotion. Maybe of course in the.
Yes. Promotion was later.
subsequent-
Promotion was later.
Subsequent stage.
Subsequent. Yes, my lord. That is right.
That's all.
That's all. my lord.
Page, what is the page 18 of the, any other?
No, my lord.
My lord, my learned friend has said.
No, it's okay, enough.
Okay.
You allow it. You grant them. All right.
All right.
You want to file the written submission?
No, my lord, if your lordship is, I need not find that unnecessary. my lord.
Now, for the convenience, you just give this
Okay, okay, I'll give.
and by Friday or Monday.
I can,
Monday.
Monday, my lord, I can. My
But
lordship
listing it
here
on
Monday. my lord.
Monday only for
Yes.
submission. You can also,
Oh,
because your.
I'll also give you
You-
four paper when half
the
page,
big one,
half page only,
page.
half page.
I
Yes.
will be very brief.
Very good.
I,
So that your submission is not missed out.
yes,
Okay. So the judgment you have relied also.
yes, yes.
Okay. All right.
Lordship.
And Mr. P.K. Roy, Senior Counsel, assisted by S.K. Chakrabarti, Counsel for the petitioners.
And why don't
And
senior
also
CJC
Mr.
for respondent 1 to
Why
5,
London Senior CJC for respondent number
1 to 5.
list the matter on Monday. Monday is what? 7. For further consideration. With an understanding that
Lordship.
for further consideration.
But Monday I'll not be here. I am having a
You
case in Itanagar.
ask somebody to
Yes.
submit. But ensure that it is submitted.
Yes,
on
by
Monday.
tomorrow. I'll submit.
Huh?
Yes.
You may not be here. You ask one of your colleagues to.
Yes, yes, yes. My
you-
junior
you
will be here.
prepare it and you ask your junior to submit.
Yes,
It's only for submission. Huh?
Yes, yes.
No further hearing.
yes, yes, yes.
But in case if I get any, any clarification has to be made, I may.
Yes.
All right.
All right.
Deep level.
I think 15 will pass over for something. Because council is.
We're hearing. Can you see that they can? No. In that case, let us not list it unnecessarily.
Yes, not regular.
Judgment, hearing concluded, judgment reserved.
Lord.
Yes.
You submit the.
Yes, that's better.
All right.
written submission. But any clarification, I may get it listed.
Lord.
Yes, we'll just go through it.
Like 15, my lord.
What is the matter?
My lord, my friend, the learned counsel is out of station.
What is the matter?
But I have not instructed them.
You read that, give the second file. We'll take it up at 2 o'clock.
Matter pertaining to Itanagar bench, orders item 3.
Good afternoon, Lordship. Yes,
Lordship,
will issue notice.
Lordship, I'm seeking adjournment on behalf of the conducting council, Kaushik Chaudhary. He's praying for the adjournment of the matter and praying to be listed on 1 of the May. So can it be 1 May? First of-
Issue notice.
Yes,
Will be
Lordship.
filed.
Yes.
Issue notice and
Respondent is appearing.
yes, Lordship. I'm for the
Ah.
respondent number
Respondent number
1, Lordship.
1,
Yes,
1
Lordship.
and 2.
1 only, Lordship.
Will issue notice. And Mr. K. Lowell, then counsel for the applicant. Next paragraph. This is an application under Section 5 of the Indian Limitation Act 1963, seeking condemnation of one 111 days
Yes, Lord.
in filing the connected review petition against the order dated 25/10/2024, passed in RFA 01 of 2016. Issue notice to the respondents. Next parent, Mr. Since Mr.
B. Lona.
D. Lona London. Counsel enters appearance and accepts notice on behalf of respondent number one, no comment, and the notice in respect of respondent number, a formal notice in respect of respondent number one is waived. London counsel for the petitioners to take steps for service of notice after respondent number two by respect for
Lordship, Mr. Lolen is for the petitioner itself.
Hmm?
Lolen is for the petitioner.
That's what I said.
Yes.
Hmm. Lona,
Okay.
the Lona. Hmm. List after 3 weeks,
Lordship, can it be on fixed date, Lordship, on 15th May?
after 4 weeks. Huh?
If the Lordship can fix
Lordship,
the date.
I humbly pray for the fixed date,
Counsel is
Lordship.
coming from outside Delhi, sir.
From where?
From Delhi.
Why from Delhi? For condemnation Delhi.
The client have agreed.
You are competent enough, it's okay.
Lordship,
When it should be fixed.
I'm humbly praying that matter may be fixed on 15th May.
Hmm.
15th May, Lordship.
List after 4 weeks on 15
15th May.
05/22. 25.
Much obliged, Lordship. Obliged, Lordship.
Right, Mr. Lordship.
Yes.
Lordship, I am appearing on behalf of Mr. Isar Ahmed, my lord.
Hmm.
My lord, he is out of station, my lord. So matter may pass over for the period.
What is the matter?
Matter my lord, regularization
Of what?
of service. My lord. I am not in this case, my lord.
I have requested you take the second file and read. Huh?
My lord, I am not in this case, my lord. I am not the enemy.
Yes, affidavit.
File affidavit, otherwise lordship, the lordship may kindly peruse page number 77, lordship, annexure 16. The petitioner has been accommodated as teacher,
16.
lordship, annexure 16, page number 77. Now he has accepted the appointment letter, accommodation letter, lordship. Because he came under the purview of that illegal and irregularly appointed teachers initially.
Hmm.
Now, in terms of the cabinet decision taken in 2020, lordship, he was accommodated. This is his appointment order, lordship,
Age what?
as a teacher, assistant teacher. And if your lordship may see the terms and conditions, lordship,
In excessive power control of the is subject to satisfactory for police verification. Assistant teacher.
assistant teacher, lordship.
Hmm.
So. And this accommodation is with prospective effect,
Rajia Begum.
lordship. It is mentioned here, the accommodated teacher will get the prospective effect from 1/11/2020. Only, and he or she cannot claim any benefit whatsoever in respect of past services rendered by him or her prior to 1/11/2020. Therefore, he has been accommodated as a teacher, Lordship.
2021, right?
Lordship.
This petition was filed.
This petition obviously was filed after this accommodation letter was issued.
Hmm?
This petition has been filed after this accommodation order has been issued.
So why is he not challenging this appointment order?
No, there is no challenge. That appointment letter has not been challenged. He is asking for the regularization
Regular
from,
service affairs, the Lord, with effect from, in terms of the advertisement.
in terms of the advertisement, but Lordship, what happened, the background is that, Lordship, during the period of 1989 and 19...
Okay, if
Lordship,
he's not interested.
Let it be on Friday or Monday, council.
On the prayer of Mr.
MR Khandokar.
M.R. Khandokar, Land Council, appearing on behalf of
Mr. HR Ahmed.
H.R. Ahmed, Land Council for the petitioner. And prayer not being objected to by Mr.
PN sir.
P.N. Sharma, London Standing Council, Elementary
Elementary.
Education Department, Comma. This matter after 4 weeks.